Okay, so here's an update to the case that nobody really likes, but still a lot of people are interested in. That is the NewJeans case. Because they have lost their appeal to lift the ban on independent activities. The Seoul High Court today ruled that their exclusive contract with ADOR is still valid and that trust has not legally broken down. All right, so I have found this article that summed up the court decision the most well. I've translated, so I will translate it for you. And at the end, let me do a brief analysis. No groundbreaking anything, but still the court decision update. All right, so here's the title of the article. NewJeans' ban on independent activities upheld. High Court said honoring the contract is an obligation. There we go. Reported by Lee Sung-hwa. The girl group NewJeans is currently in a dispute with their agency ADOR over their exclusive contract, has once again lost their legal challenge to overturn a court order that prevents them from pursuing independent activities. On June 17th, the Seoul High Court Civil Division 25-2 with the presiding judge Hwang Byung-hwa dismissed an appeal filed by all 5 NewJeans members seeking to overturn the injunction that prohibits them from acting as their own agency or signing separate advertising contracts. The court stated, the exclusive contract in question is clearly between the agency, ADOR, and the artists, the members. The conflict with HYBE and former ADOR CEO Heejin does not, by itself, prove that the trust between ADOR and the members has irreparably collapsed. Okay, here's a photo from last November. The court pointed out that ADOR has been actively reviewing various plans for domestic fan meetings and other activities and has repeatedly requested meetings to discuss future plans, but the members have refused to communicate. And indeed, according to the slides that Dispatch reported before the grand court decision, saying that the demands made by NewJeans are thereby rejected by the court, HYBE has discussed eternally about like bunch of projects planned for NewJeans, such as fan meetings, new albums, and even a world tour. Here's a screenshot of an email sent by Lee Do-kyung, VP of ADOR, to Kim Ju-young, the current CEO of ADOR. When was it sent? Does it say? November 12th, 2024. The court further noted, even though ADOR has been fulfilling its duties as a management company, the members claim that trust has been broken merely because they want a specific producer back, that is, Heejin, or are disappointed with ADOR. Such reasons do not amount to objective proof that trust is truly broken. Therefore, the legal condition for claiming contract termination based on a total breakdown of trust is not met. Reasonable. Regarding the risk of misleading the public, the court explained, public perception and outward image are crucial in the entertainment industry. Yet, on March 23rd, the members held a concert in Hong Kong under the name NJZ without involving ADOR. If their independent activities continue unchecked, the public could wrongly believe the exclusive contract has been fully terminated, which could seriously damage the NewJeans brand value. So it turns out that their decision to have a concert in Hong Kong with the name NJZ really backfired. And at the time, ADOR said that we will deploy our staff to Hong Kong to help out your performance, but NewJeans members kind of sort of literally ran away from ADOR staff at the airport, if I remember correctly, and then they never gave them ADOR staff an opportunity to help them. And yeah, from the court's perspective, this was really a bad decision on NewJeans' part. The court also rejected the argument that the injunction would force the members into a prolonged hiatus, saying this is a loss they have caused themselves by refusing to honor a valid contract. In fact, ADOR is a party suffering damage as a result. Let me read this in Korean because I think this was a really crucial point that they made. 활동 금지 결정으로 멤버들에게 장기간 공백기가 발생한다는 주장에 대해서도 채무자들이 적법한 전속 계약의 이행을 거부함에 따라 발생하는 것으로 스스로 야기한 손해에 불과하고 오히려 채권자가 그에 따른 손해를 입게 된다며 받아들이지 않았다. Bam! Wow. Yeah. Since the members... No. The court also rejected the argument that the injunction would force the members into a prolonged hiatus, saying this is a loss that they have caused themselves by refusing to honor a valid contract. In fact, ADOR is a party suffering damage as a result. Boom. People say that, I know Korea is not a perfect country at all, but I've heard a lot of people saying that, oh, in Korea, rule of law doesn't exist. But here's a very example that rule of law still remains intact, at least from my perspective. Again, Korea is not perfect at all, but yeah. The court concluded, since the members are bound by the exclusive contract, complying with it is their obvious obligation. Requiring them to do so until the main lawsuit over the contract's validity is resolved does not violate their freedom to work or create art. There you go. Previously, on March 21st, the court had sided entirely with ADOR's request for injunction, banning the NewJeans members from all entertainment activities, including advertising, songwriting, composing, and singing, without ADOR's approval. The members filed an objection, which the court dismissed on April 16th, reaffirming the original decision. They then appealed immediately, but this appeal has now been dismissed as well. I have made a video about it, right? Separately, the court has also approved ADOR's request for indirect compulsory enforcement. If any member carries out independent activities without ADOR consent, they must pay 1 billion Korean won per violation, which I also covered recently. Meanwhile, the main lawsuit, where ADOR seeks confirmation that the exclusive contracts are valid, is still ongoing. The court has encouraged both sides to settle, but the members have firmly rejected this. All right, so that's it. Once again, no surprises. And interestingly, back on June 10th, according to this website where you can actually see the procedure and what is going on with the case, is accessible for everyone if you know the case number. For this, the case number is 2025-La-2421. On June 10th, NewJeans side and their law firm Heejin have submitted USB as evidence. God knows what is in there. And I saw some pro NewJeans fans excited that this could blow a damage to ADOR and this could be a game changer, but nope. The court rejected. So, yeah. Quick summary. The Seoul High Court indeed rejected NewJeans' appeal to lift the injunction that bans them from doing any entertainment activities without ADOR's approval. What was the court's reasoning? Well, first, the exclusive contract is still valid, and the conflict with HYBE and NewJeans does not prove trust is completely broken down between ADOR and the members. ADOR has been trying to plan activities like fan meetings, new album, even a world tour, and they tried to communicate, but the members have refused all discussions. And the members attempt to perform independently using NJZ as a name in Hong Kong could mislead the public and damage the NewJeans brand. Alright, so the bottom line is the ban remains in place, and if any member works without ADOR's consent, they must pay how much? 1 billion Korean won per violation per member. And this appeal decision does not end the main lawsuit about whether the contract is ultimately valid. That case is still ongoing. Okay, so in short, ADOR's legal position just got stronger with this decision, and NewJeans must follow the contract for now or pay huge fines. And the main fight over contract cancellation is still unresolved. So we'll see with that. Quick analysis. So what can we infer, or what the High Court ruling really tells us? First of all, ADOR strengthened its legal hand. So by upholding the injunction, the court made clear that the contract is presumed valid until proven otherwise, and ADOR's baseline duty of care as a management company appears acceptable in the eyes of the law. They're not being seen as negligent or unfit. In fact, ADOR has been continuing to upload new content on the NewJeans YouTube channel, and yeah, I get notifications every time that happens. And it weakens the trust breakdown narrative that NewJeans and MiniJeans camp have been pushing in public. And why this matters? Because in any contract fight, the burden shifts if one side is presumed in breach of trust. But this ruling means that NewJeans still looks like the breaching side in the eyes of the court, unless they can prove otherwise later in the main trial. All right, secondly, the trust breakdown argument, like I said, is losing traction in court, even though that's what they're trying. The court rejected the idea that fighting with HYBE and MiniJeans, automatically breaks trust with ADOR as a company. They noted that ADOR is offering real plans, and NewJeans, on the other hand, is ignoring them. Thirdly, the NJZ in Hong Kong incident clearly backfired. The court pointed to the Hong Kong concert under NJZ done without ADOR as proof that the members are doing unauthorized gigs, and this could confuse the public and damage the NewJeans trademark. And this is critical because it supports ADOR's narrative that they need the injunction to protect the brand's market value. And it also makes NewJeans look non-compliant, which can hurt sympathy if the dispute drags on. With this, the judge is basically saying legally that it's not enough to say you're emotionally done. You have to show clear legal harm or breach by the agency, which Heejin law firm or NewJeans cannot prove. And this shows that the Korean court leans heavily on contractual formalities, not the idol group's subjective feelings. And that sets a tough bar for NewJeans. All right, so the bottom line is, once again, ADOR has a court-backed chokehold, so to say, on NewJeans' activities, and they can block independent gigs and threaten massive fines, and they keep the NewJeans trademark safe for now. For NewJeans, though, they're stuck unless they settle or win the main suit. And like I said, the trust is broken. Logic won't work by itself. They need hard proof that ADOR breached duty first. All right, so what's going to happen from now on? Who knows? But ADOR is clearly playing strong legal defense, and time advantage. Time is on their side, and NewJeans will likely keep using PR, fan sympathy and media to pressure. To pressure HYBE or ADOR behind the scenes. I don't know. Maybe the so-called Team Bunnies will make another statement, or the parents will make another statement. Who knows? And in fact, it is both sides who risk brand damage. The longer this drags on. But ADOR has more legal leverage today. We saw the other day how ADOR has launched a new video announcing about the audition program for a new upcoming group. But the damage has been already done. We'll have to see how many people apply to the audition. But if someone with this ambitions to become an idol member under a very well-known name such as ADOR, but if I know about this case very well, I don't want to have anything to do with a brand or an agency with NewJeans fingerprints all over. I don't know, but maybe that's just me. Maybe the demand will be super high and a lot of talented people will apply. And I indeed support the current staff working at ADOR. They're doing a very, very interesting job, so to say. Their position is really unique from many different perspectives. And shout out to CEO Kim Joo-young, who's doing a fine job currently. But yeah, we'll have to see what happens to the future of ADOR without NewJeans. All right. If you have any opinions, feel free to communicate by leaving comments. But as always, when we do so, let's try to stay positive, respectful, and classy. Peace and love. Bye-bye.